Good day, dear friends. I trust you are very fine. Welcome to another section of the series for the students of the Nigerian Law School. I believe you are settling down well and you are going through the program as expected. Right, so today I will be dropping a few tips on the overview of property law practice, particularly the applicable laws. Alright, so let's start with the general overview of property law practice. So property law practice is the course here at the Nigerian Law School that provides the student, that's the aspirant to the bar, the requisite knowledge on property law transactions, the documents required in those property law transactions, of course, the responsibility of the legal practitioner representing their clients in property law transactions. So it's an advanced aspect of land law or land law generally, but particularly it deals with the practice and procedure that are involved in property transaction generally. And at the Nigerian Law School, you'll be looking at five major transactions relating to property law in Nigeria. The first is sale of land. So in sale of land, you will learn the procedure for alienation and acquisition of interest in land. Particularly under the Land Use Act, but you also learn a part of it under customary law. So the basic knowledge you have in land law will also be applicable in regard that. So in sale of land is actually divided into two major parts. So we have the contract of sale, that is contract of sale stage, and then we have the conveyance or the alienation of interest stage. So at that point, you will learn that the document used at the contract of sale stage is the contract of sale agreement. And it is responsibility of the vendor, who is the seller, the solicitor, to prepare the document. The parties at the contract of sale stage are vendor, that's the seller, and purchaser is the buyer. Alright. So at this point, you basically look at the basic provisions of law of contract that binds the responsibility and the relationship between the parties. The second stage is the conveyancing stage, and at this stage we'll be looking at the transfer of the title and the interest in land from the seller to the buyer. But at this stage, the designation of the party change to assignor and assignee. Assignor is the vendor, that's the seller. Assignee is the purchaser. Alright, so that is sale of land, and the final document used in sale of land is the deed of assignment or deed of conveyance. The second transaction is donation of power. I call it donation of power. It is the transaction that enables a party, the landowner, to appoint someone else to represent him in transactions relating to his property, where he may probably not be around or he doesn't want to deal directly with that property. So it's called donation of power. It's a situation whereby the landowner donates the power or the authority to deal with his property to someone else to act for and on his behalf. The document used in donation of power is called power of attorney. That's what most people call this transaction. And but it's not a transaction. Power of attorney is just the document that is used to convey or to delegate someone to act on another person's behalf. It mirrors an agency relationship in commercial law, but is not exactly agency relationship. All right. The parties in donation of power are known as the donor and the donee. The third transaction in property law practice is lease. Lease is the grant Lease is the grant of a term of years to use and to occupy someone's property. So the owner of the property grants another person the right to use and occupy his property for a period of time, and so that is lease. The emphasis in lease is the reversionary interest that goes back to the owner at the expiration of the term granted. A lease is look at two transactions. A lease could be a lease itself or could be a tenancy. When is above 3 years, then is a lease, and then when it's 3 years or below, is a tenancy. The fourth transaction in property law practice is mortgages. So mortgages is basically the conveyance of the interest in a property as security in um, in consideration of repayment of a loan or performance of certain obligations. So I say that in mortgage we have both the contractual relationship and then we have the security transaction. The contractual relationship, whatever the parties agree to do at any particular time, which will be subject to performance at a given time, and then to compel the other party or to secure that the other party will perform that obligation vested in him is the security that is required. So the other party will now use his property as a security for the performance of that obligation, which is usually repayment of the money. And so at the point whereby it's required to perform that obligation, that's where the property will be used. That if it default, the property will not be used to recover the money loaned to him and all of that. So mortgage could be legal or equitable. The last transaction is bequeathment of property. Bequeathment of property is a transaction that looks at that consider a gift of property by the owner of the property to people who are considered as his beneficiary, though it's done in his lifetime, but is considered to take effect upon his death. So we say that that transaction is testamentary because it doesn't take effect until the death of the maker. So it's basically in this transaction we are looking at transfer of property by a testator to his beneficiary through a will, or where there is no will, in accordance with the customary law or in accordance with the administration of estate laws applicable within the area. So basically, these are the 5 transactions involved in property law. There are a few other topics in property law, but these 5 transactions form the basis of property law. And if you are a student in Nigerian law school, you understand the legal concept behind these topics and you understand the procedure involved in them, I tell you, you are good to go. Now, there are basically 2 principal laws that governs property law practice in Nigeria. Basically 2, and that is the Conveyancing Act and the Property and Conveyancing Law. Conveyancing Act is known as CA, while Property and Conveyancing Law is known as PCL. These are the laws that governs property law transaction in Nigeria. The Conveyancing Act is the law that applies to the old northern Nigeria and the old eastern Nigeria, which now comprises of the regions we call the South region and all of that now in Nigeria. So and a part of Lagos. So northern Nigeria, old northern Nigeria, old eastern Nigeria, and a part of Lagos. While the property and conveyancing law apply to the southwest states, the then southwest states. We have Osun, we have Ogun, we have Ondo, we have Oyo, then we have Ekiti, we have Delta State, and then we have Ekiti, we have Edo, then we have Delta. The acronym that I use for it is ODE. You have the 4 O's, you have the 2 E's, and then you have the 1 D. So these are the laws, these are the states that the property and conveyancing law applies to. I believe that this information will be useful in you navigating your path. There are other laws that are applicable to different transactions, but watch out for my next video on that. Thank you for listening. Please subscribe, share, like, and comment. Thank you.